The next case I want to touch on is called Hirota. It's a Japanese case. Hirota was a senior officer in the Imperial Japanese military. He was prosecuted before the International Tribunal for the Far East. And he petitioned, as Milch had, as lots of others had, for the Supreme Court to review. And the court was again divided 4-4. What's unique about Hirota's case, however, is that it's from the Pacific Theater. Really, for the first time since Yamashita, it's a non-Nazi case asking the Supreme Court to take a look at this. And the court needs 5 votes to review a habeas petition. It's not granting cert. It's reviewing an original jurisdiction habeas petition. And it's frozen 4-4. So the 5th vote in Hirota's behalf in December of 1948 is cast by Robert H. Jackson. Now, what's that about? Well, he says, in an opinion that sort of puts it all out on the table, I have an obvious interest in the prosecution of war criminals. But I have an obvious interest in the rule of law, too. And the paralysis of a 4-4 court is an undesirable legal situation. So in this case, I will vote to grant the review, to give Hirota his hearing before Supreme Court, from which I will recuse myself. I won't participate in the merits of this, but I will let the court actually look at the legality of this tribunal. Now, what Jackson's doing is an incredibly gutsy move, because the IMTFE, the Far East Tribunal, is modeled very directly on the IMT, the Nuremberg Tribunal. And in a sense, he's putting in the hands of some people who still have knives in their hands for him. Not just Japan, but Germany. What happens in Hirota's case is, after that hearing, the court decides 6-1 and 1 that it has no jurisdiction. That this is an entirely international proceeding governed by international treaty, agreement, and international law, and not the creation of the U.S. government, and thus not within any jurisdiction of the U.S. Supreme Court. The 7th vote, 6 are in the majority, the 7th vote is Justice Douglas, one of the Yamashita dissenters, one of the Jackson antagonists, if you will, agonizing, again, quite publicly and commendably, but saying in the end, overseas is overseas. The last vote, I said it was 6-1 to 1, was Wiley Rutledge. This is December of 1948. This is 2 years after Yamashita, which had broken Rutledge's heart, where he thought he'd done the wrong thing. And he's drafting and drafting, but never quite deciding where he comes out in this Hirota case. And he never does. And he dies in September of 1949, still having promised, but never actually having filed an opinion in the Hirota case, which I think shows some of the personal stakes and difficulty of judging. And Rutledge is a great figure, perhaps overly agonizing about the deciding process, but really trying to judge this as a matter of conscience. The next case, Terminello versus United States. Father Terminello was a priest of sorts, but a virulent racist speaker, anti-Semitic, anti-Negro, etc., etc. Speaking in a town meeting in Chicago, attracting a rabid group of supporters inside the hall and a rabid group of critics outside the hall. And of course, then they start meeting up when punches are thrown and bottles are thrown, and the cops come in and arrests are made, including Terminello, for breach of the peace. This case comes to the Supreme Court. Terminello says First Amendment, freedom of speech, and the court vindicates him. He wins that case. My focus is Robert Jackson's dissent, famous for a small phrase, suicide pact. He says, unless we're careful, the majority could turn the Constitution into a suicide pact. But what Jackson's argument amounts to in substance is, I've seen rabid mobs, Nazi Germany, 1933, etc., and what they can evolve into. And it is not the speech or the message, but the conduct that is involved in a case like Terminello's, the actual physical battle. The First Amendment is not an absolute. The First Amendment is a decision to protect the individual broadly, expansively, structurally, but not without limit. And when bottles are flying and blood is flowing and police are breaking up riots, that line has been crossed. Now that's very informed by his deep study of Nazi Germany and mob behavior as a Nuremberg prosecutor. Case number 4, very briefly, United States versus Eugene Dennis and co-defendants. Eugene Dennis was a figure in the leadership of the American Communist Party, and it was prosecuted in the late 1940s for conspiracy to overthrow the government of the United States. This is Gus Hall and Eugene Dennis and Ben Davis and etc. Huge year-long trial before Judge Harold Medina in New York, a circus trial. And this case results in convictions. The convictions are affirmed by the Second Circuit. It comes to the Supreme Court, and they are affirmed uncomfortably by the Supreme Court. What Robert Jackson writes in his concurring opinion is a meditation on totalitarianism. That some ideas are different order from all others. And what he's really writing about is not just communism or Stalin or Leninism or Marx. What he's really writing is about Hitler, about totalitarianism, about having seen what the abolition of liberty and freedom and totalitarian power aspires to be. And just like Terminello had an outer boundary that in Jackson's view had been crossed, Dennis and his co-defendants had an outer limit that Jackson and his majority colleagues believed had been crossed. I'll do a sentence on Eisentrager. The next case is called Eisentrager versus United States. And this is another merits case. It is a military tribunal. It's a complicated both Pacific and Germany situation. And Jackson writes for a court that prosecution and detention and behavior that's all entirely offshore is beyond the jurisdiction of the United States courts. Thus, Eisentrager, a Nazi war criminal being held by the U.S. in Landsberg prison in Germany, didn't commit crime, wasn't prosecuted, didn't touch U.S. soil, thus didn't touch jurisdiction of U.S. courts. That's an opinion, again, it's probably fair to call it Nuremberg protective, that has a majority of the court with Jackson writing. It's an opinion that in 2002 is the linchpin of the legal strategy that John Yoo and colleagues put together to set up Guantanamo. That 90 miles offshore is offshore. Close enough to be convenient, incredibly powerful, total lease-based control by the United States, but no foot on U.S. soil, thus no review in U.S. courts. And what the Supreme Court did in the Guantanamo war on terror cases in subsequent years was distinguish Eisentrager. Eisentrager as a full due process-based proceeding that he had been subjected to as opposed to what Guantanamo was. That's a Jackson. Number 6, Youngstown Sheet and Tube versus Sawyer. This is the return of Quirin, of Korematsu, of Hirabayashi, of Wiley Rutledge's discomfort with the Yamashita decision, although he's not around to be part of it. Harry Truman has seized the steel mills in the Korean War because labor unrest was going to shut them down and cause steel production to cease, which would be a military devastating event. And the Supreme Court takes this on a hurry-up basis, and the Supreme Court, 6-3, holds that the president doesn't have this kind of power, not as commander-in-chief, not in terms of taking care that the laws be faithfully executed, not as some inherent matter, not as national security, that Congress has to confer seizure power. And Congress in this case had. Indeed, Congress in this case, through the enactment of Taft-Hartley without a seizure power, had declined to give the president this power. The 5th and 6th votes are the most interesting parts, although Jackson writes the best opinion and the one that's the precedent of Youngstown Sheet and Tube. The 5th vote is Tom Clark's. How long does it take you to become a Supreme Court Justice, Bob? He asked Jackson in 1949. Well, I asked Hughes, he said 2, I think 4. This is 3 years on the court. Tom Clark, Harry Truman's former Attorney General, casts the decisive 5th vote against Harry Truman in this case. Because personal affection, former service, and legal representation as Attorney General doesn't mean you own my independent constitutional interpretation forever. And it's just not there. This was a permanent breach in the Truman-Clark relationship. But I think with some assistance from Jackson as a mentor to Tom Clark, a very proud moment in constitutional law.